Welcome back to the channel. Today I will be reviewing and opining on the 18 December 2019 SAC PD officer-involved shooting of Kevin Cole and Donald Thomas. I will be analyzing the three officer-involved Axon body cam videos, a bystander cell phone video, and the investigative report by the Sacramento County District Attorney, reference case number SPD 19-406493, dated 22 December 2020. There is a link to this document in the description below. I will also be analyzing some of the local media coverage. SAC PD provided a single MP4 file that contains the body cam footage of Shepard, Martinez, and another unidentified third officer. Appendix 1 contains information on the wearing and operation of the Axon body camera and police radio. These become critical in evaluating the mysterious loss of 29 seconds of critical video. Now, I realize you don't have access to that appendix. I will leave a link below for the hardcore PDF file of this that you can download. First, let's look at the location to gain some perspective of the situation. This shows the general layout of the rear of the shopping center. Note the extended parking lot in the lower left of the screen that is full of cars and potential innocent victims from wayward bullets. This picture shows the exact location of the shooting. The line of fire was from right to left into the parking lot. This area was generally behind the facility and not that heavily frequented by shoppers. Parking is nearby to the south. Cole went to the Panda Express restaurant and purchased order-out food. Cole had leashed his dog to a shopping cart outside of Panda Express to park the dog because he cannot take the dog into the food establishment. Cole then takes the food and shopping cart around to the backside of Panda Express and sits down to eat and package his food. The mall security guard thought Cole was a homeless vagrant and did not want him hanging around. The mall security guard told him to leave, and when he did not leave, he roughed him up a little to get him to move. Cole states that he was shoved off the sidewalk. Cole was adamant that he was a paying customer and had a right to be there. Cole states that he has a right to take 30 minutes to eat his food. When Cole still refused to leave, the security guard called Officer Shepard. Shepard was a SAC PD officer in uniform who was under contract to provide security services at the strip mall and was on site at the time of the incident. This makes Shepard a de facto temporary employee of the strip mall. At approximately 6:44 p.m., Shepard was called to the scene. Officer Shepard arrives on scene and activates his Axon body cam at 6:44 and 59 seconds p.m. The previous 30 seconds of video without sound was automatically prepended to the video. We catch Cole in mid-sentence where he is complaining to Shepard that he was pushed off the sidewalk by the mall cop. Shepard states that he is sorry that Cole had a run-in with the mall cop. Cole states that he wants to press charges. Shepard is not willing to investigate Cole's charges, and Shepard asked Cole to gather his belongings and leave. This was a request, not an order. Surprisingly, none of this was addressed in the DA report. So we have a sworn officer of the court in uniform who has received a report of a battery, and he is only interested in satisfying his employer's desire to remove Cole from his property. All of this while under color of authority. Eventually, Shepard arrested Cole for failing to ID himself, which is not a crime. Cole resisted arrest. The security guard, Donald Thomas, kicks Cole's docile dog Nikki, which results in her barking and growling. Officer Martinez, who arrived later on the scene, then shoots Nikki, wounding her, Cole, and Thomas. Here was the actual shooting incident. Okay, this analysis of this entire incident requires that we understand the case law that came out of the SCOTUS-Terry versus Ohio decision and the subsequent case law that has developed since. Fortunately, the California Department of Justice releases a police officer's legal handbook, updated every quarter, that incorporates SCOTUS, Ninth Circuit, and California Superior Court case law. We don't have to be lawyers to understand and keep track of our rights. The California Department of Justice does that for us and for all sworn officers. This handbook details what police can and cannot do in just about any kind of imaginable situation, and also clarifies the civil rights of citizens in these situations. I'm going to use this handbook to analyze this incident. This means my analysis criteria should be the same as that used by the police and the district attorney. The analysis of this incident will address consensual detentions, non-consensual detention, and arrests, and the legal requirements for each. It will also address the requirements for the use of deadly force. It will also address the legal requirements for trespassing. These are all covered in the police officer's legal handbook. What follows is a timeline of critical events. The first event is a disturbance, and we don't know the exact time of the disturbance. Mall security guard observes Kevin Cole creating a disturbance at the Safeway shopping center. The exact nature of the disturbance is not known. The security guard tells Cole to leave the property. Cole refuses, and Cole states that the security guard was shoving him off the sidewalk. The security guard calls the SAC PD Officer Shepard, who is moonlighting in uniform providing security at the mall, for assistance. In the next event, Shepard makes contact with Cole at 6:44 and 32 seconds. Shepard's body cam starts recording. Shepard confronts Cole. Cole is now in a consensual detention. Next event. Cole complains to Shepard about the assault at 6:45 and 2 seconds. Cole is complaining to Shepard that the security guard pushed him off the sidewalk. Cole states that he wants to press charges. The shoving is a criminal act of battery. Shepard says he is sorry that he had a, quote, little run-in, unquote, with the security guard. It is startling that an officer would be that callous towards a battery by categorizing it as a, quote, little run-in, unquote. At this point in time, the security guard and Shepard are employees of the mall owner. Shepard does not want to investigate a fellow employee. Okay, next event. Order to leave premises occurs at 6:45 and 17 seconds. Shepard tells Cole to grab his belongings and leave. We have to address two issues: trespassing, and when does an officer on supplemental employment cease being an employee and transitions to solely acting as a police officer. The first issue is trespassing. If a property owner tells someone to leave and they do not, then the owner must tell the individual that they are being trespassed. If they do not leave at that point, then the individual is guilty of trespassing and subject to arrest. Neither Shepard nor the security guard ever trespassed Cole. It is not clear whether Shepard is acting in the capacity of a security guard or a sworn officer. If, as a security guard, did Shepard have the delegated authority from the owner to trespass customers? If he did, Shepard never gave a trespass warning. A sworn officer does not have the authority to trespass anyone. They can only arrest someone who has been trespassed by the owner and refuses to leave. Shepard appears to be acting in the capacity of a security guard. The criteria used to determine the transition from an employee back to an officer is indeterminate. Next event, request to leave. 6:45 and 22 seconds. Shepard tells Cole that, quote, "we would like you to leave." This utterance is merely a request to leave, not an order. The "we" affirms that Shepard is acting in the capacity of a security guard. Cole is not required to comply with any request. Next event, unwelcome statement at 6:45 and 29 seconds. Shepard tells Cole he is no longer welcome on the premises. Did the security guard tell Shepard to make this utterance? This is something a mall employee would say, not an officer. Next event, non-consensual detention number 1, 6:45, 34 seconds. Cole moves towards Shepard. Cole tells Cole to back up and stay right where he is. Shepard is in uniform and under color of authority. Shepard has just placed Cole into a non-consensual detention for officer safety. Shepard has ceased being an employee and is now acting solely as a sworn officer. So everything that occurs after this must be evaluated as a sworn officer. Next event, a statement, 6:45 and 42 seconds. Shepard states that he can smell alcohol on Cole's breath. Next event, a request at 6:45:51. Cole requests Shepard's commanding officer to come to the mall. Shepard ignores the request. Next event, order to leave premises and release from detention. 6:45 and 52 seconds. This was probably an illegal order. This was a release from detention number 1. Cole is now free to leave. Next event, statement at 6:45:59. Shepard tells Cole he is causing a disturbance. There is no penal code for a disturbance. Detention number 2 at 6:46:07. Cole stumbles towards Shepard. Shepard tells Cole to not continue to walk toward him or else he will be in handcuffs. Shepard asks Cole if he wants to go to jail tonight. Shepard has restricted Cole's movements. That is a non-consensual detention. Next event, order to leave premises. 6:46:45. Shepard tells Cole he is no longer welcome here. Just grab your things and leave. Probably an illegal order, but is also a release from detention number 2. Next event, statement at 6:47. Even. Shepard tells Cole he should leave. Not an order. The word should is not an order. Next event, order to leave premises at 6:46:47. Shepard told Cole to grab his things and leave. That was probably an illegal order. Next event, an illegal order at 6:47:05. Shepard orders Cole to listen, quote, "listen, get out of here," unquote. This was not a legal order. Shepard gives Cole 10 minutes to leave or he's going to arrest him for being drunk and disorderly. This was a threat to coerce compliance. Shepard had probable cause for an arrest. Next event is a statement at 6:47:14. Shepard tells Cole he needs to go. Just leave. You need to go. Next event is a statement at 6:47:31. Shepard tells Cole he has 10 minutes to leave the property or he's going to be in the back of a car and his dog is going to be impounded. If he is not gone, Shepard will take Cole to jail for drunk in public and disorderly conduct. Shepard is clearly stating he already has probable cause for an arrest. Next event is a request at 6:48:07. Cole tells Shepard he wants his boss right here, now. The request is again ignored. Next event is a question at 6:48:15. Shepard asks Cole what he is doing to his dog. In depositions, Shepard said he thought Cole was strangling his dog. The video clearly shows that Cole was controlling his dog by his leash. This seems like contrived testimony on Shepard's part. Next event, illegal order, 6:48:17. Shepard tells Cole to pack his things and leave. Next event, radio call, 6:48:48. Shepard tells dispatch he can smell booze and that Cole is clearly high on something. Next event, illegal order at 6:48:54. Shepard tells Cole to get his things and go. You're about to go to jail. It's an imminent arrest. Next event, medical safety detention number 3, 6:49:21. Shepard tells Cole that he does not think that Cole can safely take care of himself and is no longer free to leave. He is to stay right there. That's a detention. This is now a non-consensual medical custody detention. These are unusual detentions for the safety and well-being of an individual. It is not for investigation of criminal offenses. Shepard never requires a paramedic response to deal with the medical detention he has placed Cole into. Next event, statement, 6:49:47. Shepard tells Cole to find out where he can put his dog. Cole is in a non-consensual detention and he is not free to go or move about and cannot comply with this request. The dog is on a leash attached to the shopping cart. All Shepard needs to do is order Cole to step away from the shopping cart, which he never does. This would have taken the dog out of the equation. Next event, request for info, 6:49:30. Shepard asks Cole for his name. Cole is not legally required to provide his name and does not provide it. Next event, statement, 6:49:55. Cole wants to leave and Shepard tells Cole twice that he is not leaving. Shepard seems confused about what he's doing. He wants Cole to leave and now he doesn't. Cole is under a medical detention, but Shepard still does not call for medical assistance. Next event, legal order, 6:50:19. Shepard tells Cole to take a seat 4 times. Cole violates these legal orders. That's resisting a peace officer. The DA does address this issue. The next event is placed under physical arrest at 6:50:25. Shepard states, quote, "That's it," unquote, and tells Cole to turn around and place his hands behind his back. Cole resists this legal order. This terminology is widely accepted as an arrest statement. And so it'd really be resisting arrest. The DA never addresses this issue. Next event, reason for arrest statement, 6:52:26. Cole asks Shepard why he arrested him. Shepard tells Cole that he asked for his name and refused to identify himself. California is not a stop and ID state. Failure to identify is not grounds for an arrest. This was an illegal arrest. Cole then offers to show Shepard his ID multiple times. Shepard had probable cause for an arrest for drunk and disorderly right from the start of the consensual detention. He subsequently had probable cause for arresting him for resisting an officer, which is a process crime. But he finally chooses to make an illegal arrest for failure to identify, which is not a crime. The DA never addresses any of this and never reveals if Cole was booked for any crime or if any indictment arraignment took place. Okay, that's the end of the timeline. The DA report never states that Cole was under arrest, only a non-consensual detention. The DA does state that Cole could have been charged with resisting a peace officer for trying to walk away. The DA said Shepard had placed Cole into an investigatory detention for disorderly conduct, but the video really doesn't support that. The DA reports does address 32 seconds of missing video from Shepard's Axon body cam. Shepard testifies that both his radio and Axon body cam were accidentally turned off, and then after he realized they were off, then turns them back on, all the while unsuccessfully putting handcuffs on Cole. If what Shepard said is true, then the Axons should have created 2 MP4 files. The SAC PD spliced these two files together, but left 15 frames, 0.625 seconds, a blank screen without alerting the viewer that 32 seconds were missing. Let's play a snippet of where the 32-second dropout occurs and see if you can detect it. Now let's play the same snippet with an appropriate missing video notification that lasts 32 seconds, so you get a full appreciation for how much was cut out of this film. This effect is quite dramatic. One can only imagine what was on those missing 32 seconds. The following is a timeline for the missing video snippet. Okay, first event, Shepard's radio call to dispatch at 48:36. Shepard makes a radio call to dispatch. The radio is working fine. Next event, Axon audio 2-minute event reminder occurs at 49 minutes even. The Axon double audio 2-minute event reminder can be heard. We should expect to hear the next one at 51 minutes even. Next event, the Axon timestamp disappears and video and audio goes blank. Indication that this was at 50:36. This is an indication that the Axon was either turned off or the video was intentionally edited at this point. 6 minutes, 3 seconds, frame 19 of body cam MP4 video. There are 24 frames per second. This MP4 file contains the body cam of Shepard, Martinez, and another unidentified officer appended in that order. So the next event, Axon audio event reminder missing. So at 51 minutes even, this reminder is not present and is missing. Next event, video and Axon timestamp reappear simultaneously at 51:04. The Axon is either back in event mode or the video was edited at this point. There is no audio for the next 1.125 seconds. This tells us that either Shepard selected event mode 1.2 seconds after the Axon was turned on, or 1.25 seconds of audio was edited out. Next event, Axon audio event reminder, 51:05. This was the audio startup reminder. We should expect to hear the next one at 53:05. I was not able to hear the 53:05, but did faintly hear the 55:05 notice. So we had, I counted a 29-second lapse, 15 frames, or 0.625 seconds. We have a loss of 29 seconds of video. The DA reports there are 32 seconds missing. The DA report states, body-worn camera video for the responding officer was reviewed. The body-worn camera video for Officer Shepard captured the entirety of his contact with Kevin Cole, with the exception of approximately 32 seconds where his camera and radio shut off during his initial efforts to place Cole in handcuffs. Officer Shepard noticed that the dog was getting more agitated, and he attempted to gain control of Cole. He attempted to call dispatch to request that they send cover officers more urgently. This would imply that he had already requested. But he noticed that his radio and body-worn camera had shut off during the physical struggle with Cole. He turned the radio and body-worn camera back on and contacted dispatch. I could not find any audio where Shepard had asked for cover officers before the blackout. Cole spent a significant amount of time screaming, so I could have missed the call. The dispatch logs could clarify if and when a second request for backup was made. I do not have access to the logs, so Shepard's statement that he was again asking dispatch to hurry up with the cover officers appears to be either contrived or the DA report got it wrong. The question is what alerted Shepard that his radio had been turned off. It might be plausible that if in fact Shepard had requested backup and did not receive a timely response from the dispatch, that maybe his radio was not working. But that doesn't appear to be the case. Shepard probably never made that request before the blackout. The radio on-off indicators are behind his back and out of sight, and we'll take a look at how they're positioned. The Axon was set with a 30-second video buffer. What this means is that if you turn on the Axon, it is always recording video in a 30-second loop buffer. When you start recording, i.e. go to event mode, the Axon appends whatever is in the 30-second video buffer to the recording video, giving the impression that the first 30 seconds of audio were not recorded. This is normal. The Axon will beep twice when you set it to event mode, i.e. record, and every 2 minutes thereafter. The LED on top of the camera will blink red continuously. If you turn off Axon and immediately turn it back on and go immediately to event mode, the 30-second audio blank does not exist. If you're recording and turn off Axon and turn it back on, Axon creates two separate MP4 files. So let's look at some possible scenarios about what actually happened here. Scenario number 1. Shepard testifies that his Axon and radio were accidentally turned off during the scrum, but he then realizes that they have been both turned off and then turns them back on. It would only take sliding the on-off button to the off position to accomplish this. And we'll take a look at some of the pictures here of how that switch operates. You can see a picture of the Axon on-off switch and see that it would be quite possible to turn it off accidentally while wrestling with a suspect. And here are the pictures. Axon would have created two separate MP4s if the Axon had been cycled off and then back on. SAC PD released Shepard's Axon 2 videos as a single video, which means they had to splice the two videos together. They did not do a very good job and somehow inserted 16 blank frames, 0.67 gap. They did not have any problems appending the two other MP4 files without inserting any gaps. There are some problems with this scenario. First, let's look at how the body cam and radios are typically worn by the officers. The status LEDs on top of the Axon, so when an officer looks down on it, they can see the status of the Axon. But this can often be obscured by the radio handset. It should be blinking red if in event mode and beeping every 2 minutes. Shepard's testimony is that during a highly stressful wrestling match with a suspect who was actively resisting arrest, entangled in a leash connected to an aggressive pit bull, that he somehow noticed that both his Axon and radio have been turned off. I find it not credible that he could observe the status of both his Axon and radio in that situation. He also testifies that he turned both the radio and Axon back on. He has not been able to control the suspect with two hands, but he now frees his left hand and turns these two devices back on. That's simply not credible. Shepard would have had to slide the on-off switch back to on. He would then have to pause for the Axon unit to come online, and then he would have to depress the event button twice, all while participating in a wrestling match. In addition, Shepard would have had to place his left hand behind his back, locate the radio on-off switch, and turn it back to on. The probability of both the radio and Axon being accidentally turned off at the same time is extremely small. The probability of then noticing that both are off and turning both back on while wrestling with a resisting suspect in under 29 seconds is also very small and quite frankly not credible. Okay, scenario number 2. Shepard intentionally turned off his Axon off and then back on. Shepard's radio was never turned off. Possible motive: to hide his subsequent contact. Probability? It's extremely low. Scenario number 3. The SAC PD intentionally edited out 29 seconds of video and 29.625 seconds of audio. Possible motive: to hide from the public something that occurred during that 29 seconds that was embarrassing to the SAC PD and or incriminating. Probability, I think, is very high. What is even worse is that they did not even annotate the video with a warning where the dropout occurred and that 32 seconds were missing. We heard an Axon double audible at the beginning of the second Shepard MP4 clip, but this could either be an actual startup tone or a 2-minute interval tone. The Axon timestamp occurs almost exactly when we should have heard it, since the last 2-minute audible at 49 minutes even, which should have occurred at 51 even, which is very close to where we hear it. The only credible explanation is that the SAC PD probably edited out some embarrassing 29 seconds of video and audio. So we need to actually look at the shooting incident. This is best displayed on a KCRA3 cell phone video. Let's take a look at what happens. This clip is going to be played at 1/2 speed, so you can take it all in. The DA report concluded that the dog never bit any officer during this incident. In fact, the dog never bit anyone. Officer Shepard is on video stating that the dog never actually bit him, even though the dog had his mouth momentarily around his hand. A viewing of all the available film clips clearly shows that this dog was not aggressive. This film clip was widely played over several days, leaving the public with the impression that a police officer who was attacked and bitten by an aggressive pit bull dog during his duty had to defend himself by shooting the dog. When the police later discovered the truth, they made no attempt to inform the public of their misrepresentation of the facts. Is that the kind of transparency you want in your police force?
An aggressive dog physically charged the officers and attacked him, biting that officer on his arm.
Let's take a look at the actual biting frame. This is the purported moment the dog supposedly bit Shepard. Martinez was the officer that actually shot the dog sometime later and was not yet present at the time the dog mouthed Shepard. The dog never bit anyone. KCRA3 never ran a retraction. An open question: did the police ever investigate the mall cop concerning the alleged battery? It is interesting that the DA report stated that Cole also appeared to be under the influence of narcotics, which is inflammatory and not supported by the facts. According to the DEA, narcotics refer to opioids. It would have been more appropriate to state that Cole possibly appeared to be under the influence of unknown illicit drugs. Cole could have been having a diabetic episode of low blood sugar and insulin shock. It was unprofessional and a matter of conjecture for the DA report to opine on the drugs that Cole may have been under the influence of. Something rather bizarre happens during the initial struggle. Shepard is having difficulty putting cuffs on Cole. They are both essentially being entangled in the dog's leash. So Shepard reaches for the dog's collar and unlatches the leash to get the dog out of the scrum. Supposedly, this is an aggressive dog who has already assaulted Shepard numerous times, and we are expected to believe that Shepard willingly placed his hand on the collar and unlatched the leash. There is no way that someone with any common sense who really thought they were dealing with an aggressive dog would put their hands anywhere near that dog's throat. It is clear that Shepard did not consider the dog a threat and just wanted to let the dog exit the scrum. But if that were the case, then the dog did not represent a threat to life or grave bodily harm. And if that is the case, then the use of deadly force was not warranted. So what we have are the police officers testifying to the DA that the dog was acting aggressive when the video shows otherwise. The dog is now off leash and passively sitting off to the side, looking away from the scrum. The security guard is standing next to the dog. The dog alerts on Officer Martinez as he is running to the scrum. The dog stands up, his tail is wagging. Martinez ignores the dog and dives into the scrum. The dog shows mild interest as Martinez grabs Cole's legs. The dog is not growling or barking. A third officer runs onto the scene and joins the scrum. The dog again only shows mild interest and is still wagging his tail. The third officer takes note of the dog by intently looking at it. The security guard is right next to the dog. Up to this point, the dog is very mellow and no one is overly concerned about the dog. The dog is not interfering with the scrum. The DA reports that Martinez testifies he was informed en route to the scene that, quote, another officer was trying to make an arrest and there was an aggressive dog. Shepard actually broadcast that, quote, there was an aggressive pit bull on scene and requesting animal control to respond to assist, unquote. The dog never acted aggressively to Shepard. Martinez testifies that, quote, he was not initially concerned about the dog as the dog was not barking or growling when he arrived, unquote. Shepard further testifies, quote, that after having been released from the leash, the dog started barking and growling as if it intended to defend its owner, unquote. This sounds contrived and is not supported by the video evidence. If the dog was focused on protecting its owner, why did the dog not attack Shepard in the initial scrum before being released? Why did he not bite Shepard when he unleashed the dog? This is not credible testimony. Then something very important happens that the DA tries to make light of. It is the real impetus for the shooting. The DA report dryly states, quote, the video shows security officer Thomas using his left leg to attempt to nudge or redirect a dog away from the officers, unquote. Did Thomas do this on his own initiative or was he directed to do that by an officer? The DA report does not address this issue. After watching the KCRA3 video, I would characterize what Thomas did more as a kick. There were actually two of them. The dog responded pretty much as I would have responded if someone had just kicked me from behind without warning. The dog turned around and faced toward Thomas and then accidentally backed into Martinez in the scrum while retreating from Thomas, then barked, growled, and then lunged forward. Thomas, without actually biting him, all the while wagging his tail. I don't think that response was unreasonable for any dog. The dog is then seen retreating back from Thomas, back toward the scrum, turning to the left. Martinez has just heard the barking and growling behind him, and suddenly he feels the dog backing into him. It was reasonable for Martinez to think that he was being attacked by the dog at this point. He does not know the dog has just accidentally backed into him. Martinez is unaware that Thomas has just kicked the dog and provoked the response. Martinez backs out of the scrum and sees the dog assault the security guard. Martinez appears to exit the scrum with his right hand on his gun. The dog breaks off the assault on Thomas without biting him. The dog then turns to his left and lunges towards Martinez, with his tail wagging. Martinez is backing away from the dog. At this point, Martinez draws his weapon and fires a round at the dog. The DA report states that Shepard told Martinez to watch out for the dog. I could not hear that utterance on any of the body cams, but Cole was screaming a lot. It is interesting that the DA's opinion was that the officers were not trying to arrest Cole, but merely were trying to place him in detention. Quote, Martinez noted there was a security guard, later identified as Donald Thomas, observing but not participating in Cole's detention, unquote. If it was a detention, then Cole could not be charged with resisting arrest, but some other offense like impeding an officer. The DA states, the dog barked and growled at Officer Martinez from just a few feet away and began moving towards him. Officer Martinez attempted to back up, but was unable to create separation between himself and the dog. He believed that the dog was in immediate danger due to its proximity and behavior. He reached for his firearm and fired one round at the dog, unquote. What did Martinez mean by unable to create separation? There was nothing impeding Martinez from backing up further. So the reason for the discharge was his inability to create separation? That results in the suspect, the dog, and the security guard being struck by bullet fragments. Either Martinez was a bad shot or intentionally fired the shot in front of the dog to break off the assault. We need to further analyze the events that led up to this shooting. Shepard did not want to arrest Cole. He had just wanted him off the property. After being unsuccessful in his attempts to get Cole to voluntarily leave, he finally tells Cole that he will arrest him for drunken disorderliness if he does not leave. Shepard clearly has probable cause for this arrest. When Cole will still not leave, Shepard places him under arrest and orders him to turn around and place his hands behind him. Cole does not comply. I think Shepard fully expected Cole would comply, that he would place him in handcuffs, escort him to the proper boundary, and cut him loose. If he had actually arrested him and taken him to the county jail and booked him, the ADA would probably have cut Cole loose immediately. SAC PD would have had to pay the booking processing fee. A whole lot of unnecessary paperwork would have ensued. The situation was that Shepard was probably dealing with a highly impaired suspect. He has a dog on a leash that stretches between the shopping cart and the dog, and Cole is behind the leash against the wall. This is a very bad situation to attempt a forcible arrest. You never know how a dog will respond when you use force on its owner. Cole wasn't going anywhere. The dog was tethered and did not represent a risk to the officer. For some reason, Shepard decided to go badge heavy and make a forcible arrest. He should have called for backup and animal control. My opinion is that Shepard decided to escalate this situation unnecessarily. Cole resisted arrest by not allowing the officers to control his wrist to prevent him from being handcuffed. It does not appear that Cole was attempting to flee. It does not appear that he battered any officer. The scrum started with the dog on the leash, and sometime during the scrum, the dog is taken off the leash by Shepard. The DA report's factual summary appears to be somewhat factually unreliable. The DA cites significant case law, but does not cite any penal code involving the use of deadly force because there isn't any. If an officer uses deadly force inappropriately, he would not be charged with that, but some underlying criminal offense. The case law then provides the criteria to evaluate if the force used was actually inappropriate. And if it was, then a conviction can be sustained. If not, then an acquittal. But that is not what the DA's legal analysis section does. The DA never addresses any potential criminal charges stemming from the acts of any of the officers involved. 2 people and a dog were shot. Some possible charges could be battery, reckless endangerment, and illegal discharge of a weapon, just to mention a few. The DA focused instead on whether the officer was justified in using deadly force to stop the assault by the dog. Case law states that you can only use deadly force to prevent imminent danger of death or great bodily harm. You would think the issue is whether the dog assault met the criteria for danger of death or great bodily harm, but you would be wrong. The DA took the opinion that the controlling criteria was whether the officer simply believed he was facing death or great bodily harm, not whether the dog actually was a threat to life or great bodily harm. You need to let that sink in. This is the same reasoning that is applied when an officer shoots someone to death because he believed the suspect had a gun, but only had a cell phone. Think Stephen Clark. The determinant criteria used by the DA is only the perception of the officer, with a complete disregard for the underlying facts. Reference the following report excerpt. Quote, however, Officer Shepard observed Cole's condition objective symptoms of intoxication, which made Officer Shepard concerned about Cole's ability to safely care for himself. Officer Shepard determined that he needed to evaluate whether Cole was in violation of Penal Code Section 647F for disorderly conduct. When Cole began to attempt to walk away, Officer Shepard had sufficient cause to detain Cole for a violation of Penal Code Section 148 for resisting a police officer. Unquote. This narrative does not match the video. Shepard clearly had probable cause for an arrest for disorderly conduct almost immediately after placing Cole in the first non-consensual detention. Cole never walked away. Cole was glued to his shopping cart and dog. An officer can place a suspect into a non-consensual investigatory detention even though he already has probable cause. This is often done to gain more evidence of the crime without having to give a Miranda warning. This is why you should never talk to the police. In this case, I am not clear what other evidence Shepard was hoping to gather in order to build a stronger case. The DA's report states, Cole was lawfully detained when Officer Martinez arrived, unquote. The DA's opinion is clearly that Cole was under some form of non-consensual detention and not under arrest. The DA never clarifies what type of non-consensual detention Cole was actually under. Was it investigatory or was it for medical protection? It is not normal to handcuff a suspect while in detention, except for officer safety reasons and to prevent someone from harming themselves. It certainly appears that Shepard had placed Cole under arrest. In this video, Shepard clearly states that he had arrested Cole for failure to ID, which is an illegal arrest. It is interesting that the DA focuses on Cole appearing to walk away as a chargeable Penal Code Section 148 arrest, but does not even address any charges associated with physical resisting the officers placing handcuffs on him. The latter is clearly more egregious and dangerous to the officers, but both are process crimes. The DA does not even offer an opinion on the disorderly conduct, other than Shepard had reasonable suspicion to detain and investigate. Citizens can sue officers for violation of their federal civil rights under Title 42, Section 1983 for use of excessive force. Qualified immunity is rarely granted when there is incontrovertible evidence of excessive force like video. Cole was struck between the eyes by a bullet fragment. Cole has since had to undergo 2 surgeries and is now blind in one eye due to the fragment's damage. He filed a lawsuit against the police department and the city of Sacramento in March 2020, listing 15 claims, including unreasonable and excessive force, assault, battery, and false detention arrest, among others. Cole's attorney, Mark Marin, said Cole still has a bullet fragment in his skull between his eyes. Nicky the dog was treated and returned to Cole. Cole was never charged with a crime. It is not known if Cole was ever booked into the county jail. The settlement agreement was made on September 9, 2020 for $99,000. Cole was not homeless, but everyone likely assumed he was, sitting on the ground with his backpack and his dog. Cole has a neurological disorder and it takes him some time to get around, Marin said. Cole had just finished shopping and was putting his groceries in his backpack to take to the light rail to his Del Paso Heights home, Marin said. But he was perceived to be a homeless vagrant, and it was on that basis they were strong-arming him and trying to hustle him off the property, and that's what led to the ridiculous use of force, Marin said. It just shows there is a kind of profiling, not just of racial minorities, but of the poor and the homeless as well, Marin told ABC 10. Unfortunately, Mr. Cole is disabled. He has a neurologic illness, and he looks like he may be down and out. In fact, he has an income, he has an apartment, he lives on his own, he's an upstanding citizen, and didn't deserve to be treated the way he was, unquote. So was the dog a threat to the officer? Yes, the dog was. But the level of threat did not rise to grave bodily harm. What is at issue was whether the amount of force the officer chose to defend himself with was excessive. What would have been the minimum amount of force to control this dog? The officers carried batons, mace, and tasers. I would argue that a baton would have been used first, not to bludgeon the dog, but to fend the dog off and let the dog harmlessly bite the end of the baton. If the dog persisted in assault, then move on to mace, and then taser as required. Only a jury can determine if the use of force was excessive. In this case, a $99,000 settlement was reached without a trial. Many things go into a decision to reach a pretrial settlement. So the issue of whether this was excessive force remains unsettled. But the $99,000 says it was excessive. The police will probably view this as a nuisance settlement and will go back to shooting dogs and injuring, killing innocent bystanders. Whether I think excessive force was used is not relevant. If the community views shooting dogs as acceptable behavior by the police instead of using less forceful means, then nothing will change. The difficulty is that SAC PD and DA has obfuscated the actual events of this incident, leaving the public with the impression that what the officers did was perfectly acceptable. The community, by their continued silence, is affirming that this type of policing is acceptable to them. If the community rejects this type of policing, they need to forcibly communicate that to the city council and insist on police policy changes. Only then will we see types of events stop. The Sacramento mayor could also influence and drive changes to the SAC PD policies concerning shootings of dogs if he wanted to. In this instance, we have a very good video of the shooting event. In Scott versus Harris, 2007, SCOTUS ruled that when two parties have conflicting stories and one party is blatantly contradicted by incontrovertible video evidence, which is our case, then the court can disregard that testimony and make a ruling of fact based on the content of the video. This is why you always want to video police activities and why police never want you to video them. The police say that the dog was aggressive and assaulted the officer, potential grave bodily harm. The video says otherwise. We have to stop and realize this dog assaulted two people in this incident with two very different outcomes. The first was against the security guard, which was well deserved. The guard responded by standing very still and keeping his hands by his side. The dog never bit him, and the dog quickly backed away. The second assault was against the officer, who backed away but did not stand still and did not keep his hands by his side. The officer made the decision to draw his gun and fire to stop the assault, which resulted in two people and a dog being shot. I think this officer made his decision based on a lack of training. A dog acts on his instincts as a predator. His attack and defense mechanisms are barking, growling, and biting. The dog will bite anything presented to him. If the officer had drawn his baton and extended to the dog may have bitten it and then backed off. I have used this technique very successfully myself on several occasions and never been bit. No need to use mace, a taser, or a gun. It's just a matter of training. An officer is required to use the minimum amount of force to get the job done. My opinion is that the use of lethal force in this situation was a classic example of excessive force, and probably so did the insurance carrier. Let's be clear about this officer's attitude about shooting this dog in a busy shopping center with two fellow officers, a suspect, two security guards, and three or more immediate bystanders. Let's take a look at the scene. The logical outcome of discharging his firearm in this situation was that others could be lethally or seriously injured, which they were. It smacks of a me-first attitude that the only thing that matters is that I go home unharmed, no matter how many others are injured or killed. I am sure his two fellow officers would have had a different opinion of his decision to use deadly force in this situation if they had been struck or killed. It would not be unreasonable to consider the discharge of his weapon in these circumstances as criminal reckless endangerment. The SAC DA never even considered it. This mindset is never going to change until something drives a change. It appears that the only thing that will drive change, the way the police do their business, is to video their activities and sue them often. Only when the financial burden of paying civil damages becomes too great for the SAC PD will any change occur. This SAC DA report stated that they would address only whether any of the police involved committed any criminal acts. They did no such thing. It does not address whether any of the officers involved violated any of the participants' civil rights. Violations of civil rights is a civil matter that can only be addressed in federal court under Title 18, Section 1983. I think I made the wrong reference earlier. There are no criminal penalties if police deny someone their civil rights. There are rarely any indictments when police commit perjury. It has become so bad that it is often commonly referred to as testifying. There is no criminal liability when prosecutors withhold Brady material. Most citizens do not understand their civil rights. However, it is not enough to just understand those rights. You must assert those rights in a proper and timely manner. If you do not, then you forfeit those rights. Such is the current state of affairs of the rapacious and predatory criminal law system in the U.S. Even if you assert your rights in a proper and timely manner, there is no criminal liability when a police officer intentionally denies or chills your constitutional rights. If an officer places you into a non-consensual detention, he is supposed to have specific and articulable suspicion that you have, or in the process of, or about to commit a criminal act. He is not required to state those facts to the suspect. He is not allowed to place you in handcuffs or put you in the back of his police car or to transport you anywhere except for some limited safety situations. Yet this is routinely done. They cannot take you downtown for questioning. You have to verbally assert your rights that you are not consenting to the police officer's illegal action at the time the actions are taking place. If you do not, then it will be assumed that you are consenting to the forfeiture of your rights. Let that sink in. Even if you do assert your rights in a proper and timely manner, the police will still do whatever they want. Never verbally challenge police authority or physically resist. Do not even mention that they are violating your rights. All you can do is assert your general right to remain silent, that you do not consent to seizure of your person or property, and that you demand your lawyer be present during all questioning. If possible, video record all police interaction. You must notify your lawyers that the police violated your rights, and they can bring those issues up in a suppression hearing and later in a federal civil rights case. You cannot beat the police on the streets. You have to wait till you get into court to address these issues. Unfortunately, that is a very expensive process, which means justice is often out of reach for most citizens. This biased legal process is further exacerbated by the fact that it is difficult to find effective counsel. And when you do find it, their fees are out of reach for most citizens. Basically, the average citizen is screwed. Again, there's no criminal liability if an officer denies you your civil rights or due process. The officer can be sued civilly as an individual for violating your rights. You cannot generally sue the police department or municipality except for Monell claims. These are very rare. The police union contract with the municipality most always requires the municipality to carry an insurance policy to indemnify the officers for their official acts. So when you sue an officer, the insurance company immediately steps in and represents the interest of the officer up to the amount of the policy limits. Any settlement over that amount, then the municipality will have to approve the additional funds. The municipality is normally required to do this per the police union contract. The bottom line is that the police can deny you your civil rights with almost total personal impunity. There is nothing in the system to prevent the illegal behavior of the officers. Qualified immunity only prevents standing when the officer has acted within legal bounds. I would highly recommend reading the California Department of Justice Police Officers Legal Handbook. It clearly lays out your civil rights in just about any kind of encounter. So let's be clear, the SAC DA is not interested if the police violate a citizen's civil rights. The SAC DA actually has a vested interest in taking a blind eye about police misconduct. If the SAC DA started holding the police accountable, the police would sabotage DA court cases in retaliation. So let's look at the current police culture as it responds to dog assaults and battery. I refer to you to an article written by John Whitehead. I will provide a link in the description below for this full article. I'm going to read some extensive excerpts from the article and also provide some commentary. Quote, in too much of policing today, officer safety has become the highest priority. It trumps the rights and safety of suspects. It trumps the rights and safety of bystanders. It's so important, in fact, that an officer's subjective fear of a minor wound from a dog bite is enough to justify using potential lethal force. And that's exactly what we saw in the SAC PD shooting. It is estimated that a dog is shot by a police officer every 98 minutes. The Department of Justice estimates that at least 25 dogs are killed by police every day. The Puppycide Database Project estimates the number of dogs being killed by police to be closer to 500 dogs a day. In 1 out of 5 cases involving police shooting a family pet, a child was either in the police line of fire or in the immediate area of the shooting, and in some cases, the child are actually shot and killed. As journalist Radley Balco points out, in too much of policing today, officer safety has become the highest priority. It trumps the rights and safety of suspects. It trumps the rights and safety of bystanders. It is so important, in fact, that an officer's subjective fear of a minor wound from a dog bite is enough to justify using potential lethal force. And that's exactly the opinion that the Sacramento DA took. Subjective fear was the basis for the subjective DA position. It doesn't take much provocation for a cop to shoot a dog. Dogs shot and killed by police have been guilty of nothing more menacing than wagging their tails, barking and greeting, or merely being in their own yard. Pretty much what happened in this incident. Balco has documented countless dog shootings in which a police officer said he felt threatened and had no choice but to use lethal force. Let's put this in perspective, shall we? We're being asked to believe that a police officer, fully armed, trained in combat, and equipped to deal with the worst-case scenario when it comes to violence, is so threatened by a yipping purse dog weighing less than 10 pounds that the only recourse is to shoot the dog. This is not an exaggeration. It's just convenient for the police to do it. If this is the temperament of police officers bred by the police state, we should all be worried. So what's to be done? Essentially, it comes down to training and accountability. It's the difference between police officers who rank their personal safety above everyone else's and police officers who understand that their jobs are to serve and protect. It's the difference between police who are trained to shoot to kill and police trained to resolve situations peacefully. Unfortunately, more and more police are being trained to view themselves as distinct from the citizenry, to view their authority as superior to the citizenry, and to view their lives as more precious than those of their citizen counterparts. These dog killings are, as Balco recognizes, a side effect of the new SWAT, paramilitary focus in many police departments, which has supplanted the idea of being an, quote, officer of the peace, unquote. Thus, whether you're talking about police shooting dogs or citizens, the mindset is the same: a rush to violence, abuse of power, fear for officer safety, poor training in how to de-escalate a situation, and general carelessness. It's time to rein in this abuse of power. A good start A good place to start is by requiring police to undergo classes annually on how to peacefully resolve and de-escalate situations with the citizenry. While they're at it, they should be forced to demilitarize. No one outside a battlefield should be equipped with the kinds of weapons and gear being worn and used by local police forces today. Ultimately, this comes down to better and constant training in nonviolent tactics and serious consequences for those who engage in excessive force, and a seismic shift in how law enforcement agencies and the courts deal with those who transgress. In terms of our four-legged friends, many states are adopting laws to make canine training mandatory for police officers. As dog behavior counselor Brian Kilcommons noted, officers' inclination to take command and take control can cause them to antagonize dogs unnecessarily. Officers need to realize they're there to neutralize, not control. If they have enough money to militarize the police with military vehicles, they have enough money to train them not to kill family members, and pets are considered family. After all, as the Washington Post points out, while postal workers regularly encounter both vicious and gregarious dogs on their daily rounds, letter carriers don't kill dogs, even though they are bitten by the thousands every year. So why are we not arming our postal carriers? Are cop lives and well-being above those of postal carriers? If it is acceptable for cops to use deadly force to stop a dog attack, why not postal carriers? And yes, I understand there's a difference when a suspect may intentionally use his dog to assault an officer. Instead, the Postal Service offers its employees trainings on how to avoid bites. Using live dogs, handlers, and trainers put postal workers through numerous scenarios to teach them how to read a dog's behavior and calm a dog or fend it off if necessary. Meter readers have also benefited from the same training, drastically reducing incidents of dog bites. Programs need to be instituted aimed at training police to de-escalate their interactions with dogs rather than resorting to lethal force. There will be no end to the bloodshed of unarmed Americans or their family pets until police stop viewing themselves as superior to those whom they are supposed to serve and start acting like the peace officers they're supposed to be. I would recommend you read the article for yourself. It is astounding how many innocent people are killed or wounded from these dog shootings. I've appended the 3 SAC PD body cam segments for your review.